All rise. Court is now in session. The Honorable Judge Sunnyday Kavanaugh presiding.
I hate this chair always in the way. Hello, good evening. This chair is Sunny Kavanaugh. There are a few more people in here. Let me see some rules. Please be respectful for the court. If you're going to be talking, please be whisper, not to disrupt proceedings. Don't please be on the silent. I always forgetting myself. Let me do this.
Choices and go to sleep.
Let me do this now. Delete, not disturb. That is pretty much it. We're pretty flexible. Just don't be crazy or disrespectful. Let me see. Are we prepared to proceed?
Yes, Your Honor. I do just have a couple of things I'd like to bring up before we begin.
The defense is ready, but we're excited to hear what the state has to bring up.
Okay, give me 1 second. We already introduced. I'm familiar with the representations and defendant. Just for the clarification, the charges. Prostitution, what are the charges?
Just a moment, I will get them up. The charges are going to be 4 counts of unlawful possession of a Class 1 firearm, 1 count of fleeing and eluding by foot, and 1 count of weapons trafficking.
And defendant maintain not guilty all.
Not guilty to all, Your Honor?
Perfect. What is your motion? Alexa, turn my bedroom light to white.
So, firstly, Your Honor, the state would like to object to the case law provided by the defense on the basis of relevance. This has nothing to do with a traffic stop, a vehicle flag of anything of a kind. This was a hostage that was searched under exigent circumstance.
I have an explanation if you like, Your Honor.
Oh, I did not see this. Let me have a minute to review this.
Of course.
I'm eating some food. This what is your rebuttal?
Yeah, according to Title 1.8.1 of the Procedure of the Court, internal case law can be brought forward by either party without the prior approval of a judge or of the courts or justice. Additionally, this case law is in respect to charges levied after the case of an illegal stop or a lack of RS or PC, which I think is prevalent here.
Your Honor, if I'm off for a rebuttal.
Yes, you may rebuttal.
Whilst Mr. Moss is correct that he is more than welcome to bring any case law without prior approval of a judge, that does not stop the opposing counsel from objecting to such. Once again, I am objecting to such on the basis that whilst it is talking about illegal searches, it does not have any mention of any kind of exigent circumstance, which was the basis of the searching question, and as such, that case law is completely irrelevant.
I can further elaborate if you wish, Your Honor. It's up to you.
You may have one final elleboration.
Yeah, the mention of exigent circumstances is not mentioned here. Additionally, exigent circumstances generally applies to items where evidence may be quickly abandoned or destroyed, such as vehicles and whatnot. That has nothing to do with a person or a witness to a crime of which there is no PC or RS involved.
I can also further elaborate, Your Honor, or if you are willing to let me do so.
Interesting arguments. Yes, you may elaborate.
Exigent circumstances, as Mr. Mosso kindly pointed out, can refer to destruction. We're referring here to the potential destruction of evidence that could or could not be planted on a hostage who is in fear of their safety during an incident. Therefore, the search was carried out as an administrative search of which exigent circumstances are particularly beg your pardon. Exigent circumstances are particularly the reason for those administrative searches to avoid destruction of evidence.
Your Honor, I have one last comment. I promise it's no more than 8 words.
You can have 7 words.
Exigent circumstances require probable cause.
Oh, very good. That was 5. Give me 2 minutes to consider this. I will be right back. Don't go anywhere. I'm gonna read this freaking case law. What are your thoughts?
Mine?
I mean, I don't care if the case law is there.
Yeah, I don't think you can object to case law being admitted. It's up to you if you want to follow it. It's not binding case law. It's made by a magistrate, but it's not an appeal or anything. It's just a magistrate's. But I don't think we should suppress case law that was found in the state. Like it says. It's up to the judge how they want to interpret it and go off of the case law, but there's no reason to suppress it being on the docket. I don't think you can suppress it. It's not a piece of evidence. He's just providing an excerpt from established case law, which is like its own sort of thing that you can take judicial notice of and do whatever you please with.
Yeah, that is what I'm thinking.
Yeah. Also, I had an aneurysm when he was talking about exigent circumstances and administrative searches. They need to come to law school, man. Those are not the same thing. Also, you can't exigent circumstantially search a person. Exigent circumstance mean you don't need a warrant. You still need PC, but you never need a warrant to search a person. I had such made me want to vomit.
Oh my god. That was old. I don't know. Okay, perfect.
I do it.
Ah.
All right. Court is now back in session. Signing Day Kavanaugh presiding.
Thank you, Raj.
Maybe I'll be more comfortable on this side of the chair. This chair is in the way. Somebody need to remove. Anyway, thank you all for the moments. Regarding this presenting case law, the court will make note of it. We will not be strict. This case law, we will allow it to be stand. That doesn't mean that I'm going to use it.
Thank you, Your Honor.
Understood, Your Honor.
With the bench trial, we're waiving the opening statements.
Your Honor, I do have an opening statement. If if the court's will entertain it.
Your Honor, the state would prefer that we stick to the procedure of a bench trial and exclude the opening statements.
Yes, Mr. Moss, it did be established many bench trial ago. In the interest of time, the waiving of the opening statements.
Of course, Your Honor. That's plenty fine.
I don't
Your
know
Honor,
we
if I
got
may, I
opening
do have 2 more things to submit.
Tomorrow, who what?
Two more pieces of evidence to submit, or 2 more motions rather to submit.
Tomorrow motions? Oh my
Yes, Your Honor.
god. Okay, motion number 1.
The first one was more of a clarification. It was submitted on the docket, but I just wanted to file a motion to submit the evidence that was provided. Beg your pardon. That was provided in the incident report from officers. That has been submitted to the docket, but I just wanted to file a motion to ensure that that's being submitted officially to this case to the courts.
Are there any objections to any evidence submitted to the docket, Mr. Moss?
Well, our objection are kind of central to the whole case as a whole. We have our own motion to bring up later on, so it's kind of we kind of got a mixed bag here going on.
Oh my god, I hate to hear.
The defense also has 2 motions, which one is directly related to the evidence presented by the state. To speak clearly, Your Honor. If you want, I can present the specific evidence related one right now.
So you have the rebuttal or objection to the evidence presented?
Yes. Our objection and our general motion would be to suppress the evidence related to the registered owner and the serial numbers of the guns involved, as shown in the state's exhibits 4 through 7. The motion is to suppress on the basis of fruit of the poisonous tree. The search was conducted without reasonable suspicion or probable cause. Therefore, these pieces of evidence were illegally obtained and therefore should not be submitted as evidence against my client in a court of law.
Your Honor, if I may offer a rebuttal.
What is your rebuttal?
Your Honor, these pieces of evidence were obtained under an administrative search of a hostage, of which an exigent circumstance presided in the fact that a hostage that may have had evidence on their person was searched in order to discover any potential evidence. It was upon this search that all of these pieces of evidence were found. The search is not unlawful, as the 4th Amendment, whilst it does protect individuals from unlawful searches, it also covers these administrative searches as well as plenty others that happen on a daily basis. The administrative searches are there to support these exigent circumstances, to stop the potential destruction of evidence, as well as support officers in the line of duty regarding investigations as to what happened.
Your Honor, I have a rebuttal if you wish.
Yes, Mr. Moss, what is your rebuttal?
Yeah, if the state can provide where in the 4th Amendment it provides a definition for administrative searches that circumsede the need for probable cause to search a person,
Oh my god.
I am willing to entertain it, but I do not see it in our state's constitution.
Well, Your Honor, if the defense wishes to take a 20 to 30-minute recess for me to look through the entire 4th Amendment to find the exact piece of legislation, then I'm more than willing to do that. But until then, we've acted on these exigent circumstances before. We shall continue to do so. It it shall also stand to account that these people who are taken hostage, as unfortunate as it is, are highly vital to being searched in order to actually uncover any evidence of the incident itself as well.
Your Honor, if I may, I feel like we're just going to get bogged down in motions that surround the core argument of the case itself.
Yes, I agree. I feel like many of these arguments can be done through the court proceeding.
All right.
In that case, Your Honor, I have simply one more motion I would like to file.
Oh boy. All right.
Yes, what is this motion?
It's simply to motion for subpoena of Sergeant Wiersbicker and Cadet Phoenix as witnesses. They are both the arresting officers with regards to this case.
Defense, are you having any objection to the witness and Phoenix?
No, Your Honor. Both are mentioned in the indictment. I have no objections.
It is wonderful. Perfect. Anything further?
Just very briefly, as the state has subpoenaed those witnesses, the defendants rather, would like to add them to our own witness list as well, in case we need them for direct examination.
Wonderful. That are you ready to be present the case?
Yes, Your Honor.
Of course.
Wonderful. First witness or evidence?
Oh, sorry, say that again, Your Honor.
Please present in the first witness or the evidence.
Yes, Your Honor. The state would like to call Sergeant Wiersbicker to the stand.
Do you have someone to swear me in, Your Honor? Is it? Oh, okay.
I do,
Oh.
Mr. Jupta.
Yes. You want to sit in the stand, or
I'll stand here. Or do you need to stand here? Sorry.
doesn't matter to me really. Whatever Judge
These
DeCavanaugh
chairs
wants.
don't work for me. So I'm just going to stand
All
here.
right.
Is that all right?
That's perfectly fine with me.
The court will order you to sit in the
All
chair.
right, would you like an
of
oath or
this-
affirmation?
Affirmation, please.
Do you solemnly affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Your Honor, the witness has been sworn in.
Wonderful. You may be approach the witness.
Thank you, Your Honor. Hello, Cherry. How are you doing today?
I'm doing all right. Thank you.
Fantastic.
I'd ask that the state speaks up. I didn't hear that question by Karen.
I was simply asking the Sergeant how she's doing today. Can you hear me now?
Yep, I can hear you now.
Fantastic. Just for the record, could you please state your full name?
Cherry Rizbitska.
Fantastic. Apologies if I did butcher your surname. I'm terrible at pronunciation.
It's okay.
And can you please state your main profession?
I am a sergeant with the Major Crimes Division.
Fantastic. And how long roughly have you held that position?
I've been a sergeant?
Your position in the
Alexa,
Major
turn my
Crimes
bedroom light to white.
Okay.
Hey
Oh
there.
gosh. I couldn't tell you when exactly I joined the Major Crimes Division, but I became a sergeant approximately 4 months ago.
Okay, fantastic. Alrighty, so with pertaining to this incident, let's start from the beginning. Could you tell me about the events that led up to why we're here today?
Sure. We received a call for Evangelico's store robbery occurring in Grapeseed. Myself and my cadet, which is 711 Cody Phoenix, responded to that call as primary officers. Upon arrival, there were 2 hostages inside of the store, along with 2 suspects. One of the hostages was a female. One was a male. The female was later identified as Lollipops. The male was later identified as Ivan. Wait, was it Ivan or Ivar? Ivar. I think it was Ivar. I apologize. Helsinki. After my cadet 711 Phoenix went through the negotiations and talking to the hostage takers to find how he could get the hostages out safely. At which point they demanded free passage, no air one, the typical Vangelicos demands. And then 711 Phoenix stated that to the other officers on scene that him and I would stay back to clear the store and speak with the hostages. The hostage takers took off in a V-Star, I believe it was. Don't know plate or anything like that because we didn't end up pursuing that vehicle. And the other officers took off after that vehicle. 711 Phoenix and myself cleared the store. During negotiations with the hostage takers, we did see the female hostage dropping bags of items at her feet. During the search of the store, we searched those bags and found a smaller bag, of LSD tablets and some, I believe it was 11 total rolls of notes. We exited the Vangelicos after clearing it and finding no one else inside. When we exited, Lollipots was still standing out front, but Mr. Helsinki, who we had not quite yet identified other than his attire, had disappeared. I asked Miss Potts where Mr. Helsinki had gone, and she'd said motion towards the east, at which point I'd walked towards the east and found him maybe 10 feet away, if that, in a bush. I then asked him what he was doing, and then asked him to return back to the front of the Vangelicos. Once we went back to the front of the Vangelicos, I turned to Miss Potts, spoke to her. She stated that the hostage takers had taken her from Legion Square and when inquired about the LSD tablets and the rolls of notes, she stated that the hostage takers had placed those items on her, and she dropped them on the floor because they weren't hers. She didn't want to get in trouble for having them. After that, 7-Eleven called out that Mr. Helsinki was searched and had several firearms on him. I clarified, I believe, exactly how many. And then I'm not exactly sure. There was some sort of disagreement between him and Mr. Helsinki. I'm not exactly sure what the disagreement was about. I'm sure he'll clarify. And then Mr. Helsinki began to run away when he was told that he was going to be placed under arrest. I jumped into our Stanier with 7-Eleven chasing him on foot. We've chased him through the woods, up a mountain, down a mountain. At that point, I hopped out of the patrol vehicle because there were cougars in the area, and at this point, it was too dangerous to continue to pursue on foot, both to Mr. Helsinki and to Officer Phoenix. He was tased in an attempt to subdue him. He stood up after being tased and walked across the road, the dirt road that we were on. On the opposite side of the dirt road, he was convinced to allow us to remove the restraints that he had been in. We removed the restraints, and I informed him that I was going to place him in cuffs. I placed him in cuffs. He resisted being handcuffed and started to run again, at which point 7-Eleven Phoenix tased him once more. And at this point, he surrendered peacefully and was placed in cuffs by 7-Eleven Phoenix. I checked him over medically to make sure that it was safe to move him. I do not feel comfortable removing chaser prongs, but he did look perfectly fine to move to take him to Saffir. We took him to Grapeseed Main Street, where we needed to clear up some cones that were causing road blockage, and then also allowing Saffir to come to see Mr. Helsinki and make sure he was okay. At that point, Saffir arrived, took care of his injuries. During the ride, I will say I forgot this part, sorry. During the ride from where he was cuffed to Grapeseed, Maine. He was read his rights and asked where the firearms that 7-Eleven had found on him, where they had come from, at which point he admitted that he had found them in the trash. And then he was taken care of by medical. After that, we transported him to Triple SO. We explained to him why he was searched. He seemed confused and didn't understand it, so we called for PDO for him.
Okay. Sorry, just a moment. So, just to clarify, how many attempts did it take to detain the defendant?
2 taser prongs and 2 cuff attempts. So I cuffed him, and he wiggled out of the cuffs and resisted, and then he ran away and was tased again, and then cuffed it the second time successfully.
Okay. And at what point was the defendant PID'd on scene?
Your Honor, I'd just like to get clarification on what PID is.
Positive identification.
All right, thank you. Sorry.
So we did not know his name. He had identification cards on him, which 7-Eleven will have to testify to, but we didn't know him positively as Ivor Helsinki, and I believe it's Ivor. I might be pronouncing that wrong. Helsinki, until we had him fingerprinted in the cells. However,
Okay.
if you're at, are you? Oh, sorry, never mind.
Just a moment.
Mhm.
So, again, just to clarify, was you there for the disagreement between 7-Eleven and Ivor Helsinki?
I'm going to object to leading.
Not leading. I'm simply asking if she was there.
I mean, I have further explanation if you need, Your Honor. It's up to you.
Well, did your further explanation?
He practically gave it all in the question itself. While he may think that's direct, he said, were you there for this exact purpose at this exact time? It's leading, Your Honor.
Your Honor, the witness stated that there was some manner of disagreement between her cadet
Do not
and
interrupt me!
the defendant. I am simply trying to ascertain as to whether she was there for
I
that or
believe
not.
she already said she was not there. Let me think about this. I believe the witness did assert there to be an argument. I also believe she said that she was not present.
Yeah, I'm simply asking to clarify that, Your Honor.
The court will overrule this objection and hear the responding.
I was present, however, due to the chatter that was happening on my radio, I did not hear what the disagreement was about.
Okay, thank you. No further questions at this time, Your Honor.
All right.
Oh my god. Mr. Gresslaw, please stop.
Hello, it's Sergeant, correct?
Yes. Hello.
Okay. Yeah, just to be clear, you were there for a bank robbery, correct?
Evangelicos.
For Evangelico, sorry. Well, my mistake. Apologies. Do you have any verifiable connection between the two hostages in this case?
I'm not sure what you mean
Question,
by that.
objection, relevance.
My rebuttal is that she used the female hostage admitting to these to whatever her possessions were being placed on her as justifiable reason for searching and therefore charging the defendant. So I'm trying to look for a connection between the two to see some sort of relation, some sort of link to probable cause here.
relationship between hostages, I do not believe to be relevant. The objection will be sustain it.
Okay.
The relationship is they both hostages at the same place.
All right. Did you witness any of the hostage takers give any items to the defendant?
Not during the time that we were there, no.
Okay. Was the defendant bound and blindfolded during the time you were there?
Yes, under consent, according to his own words.
Okay. What probable cause did you have to search the defendant? What crime did he commit? Or what probable cause? Sorry, I can rephrase.
Objection. This is beyond the scope of cross.
I'll rephrase.
I will let
In
him
regards
object
to the
again.
search of the defendant, what probable cause was established prior to the search?
He was present at a robbery inside of a restricted area, a locked jewelry store that had been broken open.
Okay, so that's probable cause of what crime?
Robbery of a jewelry store, sir.
Just for clarification, you were saying that the bound and blindfolded hostage is probable cause for robbery of a jewelry store.
Objection, Your Honor. This is way beyond the scope of direct questioning.
I believe I've opened the scope, Your Honor.
Yeah. Can you open the scope after the fact? I don't know why you didn't object again after the first time. The court would agree that this is beyond the scope of the direct examination. But you have him as a witness. You can ask.
Okay, just to be clear, it was just the last question that was objected to, correct? Okay, that's fine. Are you familiar with the Constitution of this state?
Yes.
Okay. Are you familiar with Article 3 of the Constitution of the state?
Yep.
I am not.
Okay. Are you aware of what that states? Article 3 of the Constitution.
The right to be free from warrantless search and seizure, sir.
Perfect. Do warrantless searches and seizure require any additional evidence?
So, are you asking me if I understand the Constitution? Can I just clarify what exactly you're asking me?
I mean,
He's going to ask all of these.
I'm going to go ahead and object, Your Honor. We're still beyond the scope of direct questioning.
by answering the initial question about the Constitution, she has opened the scope. If he wanted to object to the scope, he should have done that on the first question.
Mr. Morse, question, you did request for direct examination. Is this witness?
Yes, of course.
Are we direct examine now?
No, Your Honor, but I mean, I'm as far as I'm aware, I'm free to ask whatever questions I choose. Barring objection, they didn't object to the first question about the Constitution, which opened the scope to further questions about the Constitution, Your Honor.
Why are we arguing the fucking Constitution? I hate it here.
The state would like to reaffirm that it reserves its right to object to any question given when it sees fit to do so. And as of right now, the state believes we are well beyond the scope of direct questioning.
And the court will agree that this beyond the scope of the initial questioning from the state. That's what I am going with. Do I think it is? No, if it is right,
Okay.
I don't know. I mean, you just ask the question on your direct examination. It is
Can you
fine.
define exigent circumstances?
Sure. Would you like me
Can
to
you
read it
object?
from the penal code, or would you like me to define it a different way? Just clarify.
However, officers of this state are empowered to use it.
Okay.
hate to hear-
Your Honor, can I pull out my phone to look at the penal code?
Yes, you may read the penal code.
Okay. So I'm referencing the general laws and definitions, Article 2 definitions, reference 20 exigent circumstances. An emergency situation requiring swift action to prevent imminent danger to life or serious damage to property, or to forestall the imminent escape of a suspect or destruction of evidence. These circumstances should only be seen as viable in extraordinary circumstances and not to be used in everyday investigations. If a judge or justice is available, this cannot be used to circumnavigate the warrant application process. Abuse of this will not be tolerated.
Okay, perfect. Was this an extraordinary circumstance?
I believe that's not up to me to decide, sir. In my opinion, yes, but does my opinion rule the courtroom? No.
Okay, to follow up on this, is the Vangelicos robbed often?
Objection, relevance.
The relevance would be the exigency. It's brought up as extraordinary. Extraordinary would imply that this is for uncommon situations. So I'm trying to get to where we get to
Mr.
extraordinary here, Your Honor.
What? What is these arguments? I hate it here. One moment, please. Oh my god. I hate it here. I should have stayed asleep.
Your Honor, the state would
I am
further
deliberate.
object as to arguing the law. There's nothing on this definition that states that it has to be a rare occasion at all.
I have rebuttal if you wish, Your Honor.
One moment, please.
Of course.
Of course, Your Honor.
Stop talking. Shut up. Is it relevant the frequency of the... The court does not see how the frequency of robbery of a particular store is being relevant to the charges.
I mean, Your Honor, I
Or
have a
the
response
searching.
to that. I have a response to that if you wish.
What is your response?
The exigency stated here, and that is apparently the basis of the state's case, as the witness just stated, requires extraordinary situations. I believe if a store is, very commonly the victim of a crime, it would not be extraordinary, as it would be, in fact, ordinary.
He is arguing
Your Honor, if I may
mechanics of
rebut.
the state. Yes, what is your rebuttal?
It's not
I-
called an extraordinary circumstance. It is an exigent circumstance. There is nothing in this definition to say that it has to be a rare or extraordinary circumstance. Just that it is a circumstance as per pertaining to the definition, to prevent imminent danger to life, serious damage to property, forestall imminent escape of a suspect, or destruction of evidence.
The second sentence of it says only viable in extraordinary situations.
of which a robbery is not an everyday investigation.
I would argue that's for the witness to answer.
Here will be the court ruling. The court will sustain this objection. The court does not see the relevance of the frequency of the robbery of a particular evangelical store.
Okay.
To be, excuse me, I am thinking
sorry.
of the words.
I apologize, Your Honor.
To be necessary for the extraordinary requirement of the exigent circumstance. Yes, we live in a state that unfortunately people love to find a lot of things to rob. It is very difficult to explain this. That is all.
Okay. That's fine.
It is
Sergeant,
the only things to rob.
Do exigent circumstances require probable cause?
I believe any exigent circumstance would require probable cause. Yes, sir.
Okay. Perfect. What was the probable cause here?
He was a individual inside of a jewelry store as it was being robbed.
And just for clarification, that is probable cause of what crime?
Robbery of a licensed jeweler's. Sorry, let me get the full title. Robbery of a licensed jeweler. I don't think it's jewelers. I think it's just jeweler. No, robbery of jewelry from a licensed jeweler. I apologize. Much longer than I thought.
Okay. Were the admissions by the defendant under Miranda after the search was conducted?
Yes.
Okay. One moment, Your Honor.
Yes, he is.
Nothing further, Your Honor.
They are arguing server mechanics. His argument, this evangelical is robbed so often, it's not exigent circumstances, it's a common occurrence. Would you like to redirect?
No, Your Honor, the state will not.
Anybody plan to be calling Miss Sergeant? Sorry, I can't pronounce your name.
It's fine. It's Vierspitska. It's okay.
Vierspitska? Ska?
You got it. Hell yeah.
I don't believe the defense has any further use for this witness, Your Honor. I don't think we need the call
I'm useless. Oh,
on
that's
our
nice.
side.
The state may need to later on for a manner of clarification.
Wonderful. Miss... Where's Biska? You will be remain under the oath on the request for subpoena.
Yes,
Please
Your
be
Honor.
staying at the court.
Yes, Your Honor.
Thank you.
Oh, am I free to step down? Sorry.
No. I'm
Oh,
just
okay.
kidding, yes.
Oh, okay.
Oh my god. I don't know what to do. They were like arguing server mechanics.
Your Honor, the state moves to call Cadet Cody Phoenix to the stand.
Is Cadet Cody Phoenix being present?
Yes, Your Honor.
Wonderful. I don't know what to do in the middle of the case when they're arguing mechanics. Can I call a
Raise your
C-bar?
right hand, please. It's like an oath or affirmation.
Affirmation, please.
Oh, you're so
Do you
confident.
solemnly swear? Oh, sorry. Do you solemnly affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Your Honor, the witness has been sworn in.
Wonderful. You
Your Honor,
may
if I
stand
may
or sit.
approach.
Be comfortable. Yes, you may be approaching.
Thank you.
I'll stand if that's okay, Your Honor.
Cody, how are you doing today, sir?
Oh, I'm doing swell. How are you doing today?
Doing good, thank you. You mind if I call
I
you
feel
Cody?
the same, Cody.
That's completely okay.
Fantastic. Just for the record, could you please state your full name?
Cody Phoenix.
Okay, Cody, and what is your main profession?
I currently hold the rank of cadet in the Blaine County Sheriff's Office.
Fantastic. And how long, roughly, have you held that position?
I believe I was hired on August 2nd of this year.
Okay, just to show on the record, that would show an employment of 8 days.
He is good though. I like
7
him a
to
lot.
8 days.
Hmm?
Okay, Cody. I'm not going to ask you to go through all of the events all over again, as the sergeant did that so well. I want to address this apparent disagreement with the defendant. Could you elaborate on what happened there for us?
I'm going to object to vague and also calls for narrative. I'd ask the state to be more specific.
Okay. Cody, can you please explain to the court what happened during your searching of the defendant?
Yes. Is it okay if I talk briefly about leading up to the search of him? Just very briefly.
If that is relevant to the circumstance, then yes.
I just feel like for the slight context, it might.
Yes, go for it.
As Sergeant Wiersbecka had mentioned before, after we were finished clearing the store, making sure there's nobody left inside, we exited where our one hostage, I believe her name was Lolly Potts? Yeah, Lolly Potts, was present. Ivar was not. We found Ivar roughly 10 feet away in a bush. After he had exited the bush, I pulled him aside while the sergeant pulled Miss Potts aside. While I had Ivar, off to the side with myself, I informed him what was going to be happening. I told him that I would be performing a search. At this time, he did not, resist or decline the search. I began going through his possessions, which I initially found his heavy pistol, which ended up being registered to him, as well as 4 ceramic pistols in his possession. At this time, I began taking the firearms off of him. And at this point, it is when Ivar began getting very upset with me. He had stated that the firearms were his, and that I had no right to be taking them from him. At that point, he started to walk away from me, which I had told him that I needed to stay still, stay with me, because I wanted to cut him free from the flex cuffs that were placed on him from the individuals robbing the store. He refused to do so, and got even more upset with him when I told him I wanted to place him in my handcuffs. He started walking away from me more, and then began running away from me towards North Calafia Way. I can continue, but I believe Detective Wiersbecka covered the rest.
Okay. And just to clarify, at what point of the search did the defendant start resisting the search as to your testimony?
He began resisting the search after I began taking firearms off of him.
Okay. Did the defendant show any resistance before or as you began the search?
He did not.
Okay. Moving slightly beforehand, you mentioned that you found the defendant hiding in a bush.
That is correct.
Okay.
I'm object to leading? What?
No,
What's that?
I'm just asking for clarification. I believe you already testified to this, and I'm just clarifying.
I will sustain this objection. Please rephrase.
Okay.
I don't know why.
Where did you find the defendant?
That's all you have to do.
Initially, or at which time? I don't want to.
After the suspects of the robbery, or 1 second, let me think of how to phrase this. Where did you find the defendant at the point at which you decided to search him?
When we exited the building to search both hostages, we found Ivar in a bush roughly 10 feet away from the Vangelico store.
Okay. During the robbery in progress, did you see the defendant inside?
Yes, he was wearing his. They had a bag over his head, but yes, it was him.
Okay. And what attire was he wearing inside the building?
Other than the bag that was placed over his head, exactly what he's wearing right now.
Okay. And what attire was he wearing when you found him in the bush?
The same attire that he's wearing right now.
Okay. Just a moment.
How did he find the bush with the bag on the head?
What did the did the defendant state anything during the search?
During the search, while I began taking the firearms off of him, he was stating that the firearms were his. That was about it. Other than his objections to the search, saying that I had no right to take his belongings.
Okay. Did he state that under direct questioning?
He did not.
Objection vague?
I can be more specific. When the defendant stated that the firearms were his, had you questioned him on them, or was it a statement that he had made?
It was a statement that he had made.
Okay. No further questions at this time, Your Honor.
Cross-examination, yes?
Yes, of course, Your Honor. Hello, I'm sorry I didn't catch your name, Cadet. What was that again?
My full name is Cody Phoenix.
Phoenix, okay. I like that.
Wonderful.
I'd hope so. Perfect. While he was bound and blindfolded, what actions did the defendant take during the robbery?
He was sat on the ground.
Okay. Did he have any actions besides being sat on the ground?
None that I witnessed.
Okay. Do searches require probable cause?
Yes.
Okay. What was the probable cause for searching the defendant?
Being inside the store that was being robbed.
And that was probable cause of what crime?
Robbing the store.
So just for clarification for the courts, being bound and blindfolded in a robbery of the store constitutes probable cause in your opinion?
You're asking for my opinion?
Yes, as the officer who searched him, I am asking if I mean, I'll rephrase to be clear here. Did the defendant being bound and blindfolded constitute probable cause that allowed you to search him?
Yes.
How did you think he was involved in the crime?
It's less of thinking he's involved and more of making sure he's not involved.
Oh. So what hard evidence did you have that he was involved?
Again, my probable cause was that he was inside of the store while it was being robbed.
Yeah, I'm going to object to non-responsive.
Okay. Can you re-ask the question?
I mean, if you want. Yeah. What evidence did you have that he was involved in the robbery?
Again, he was inside of the store.
Okay. What is probable cause?
You're asking me what probable cause is?
I sure am.
Sure. Probable cause is backed up by evidence that allows officers of the law to arrest and search an individual with the belief that they have, will, or are committing a crime.
Okay. How does that differ from reasonable suspicion?
Objection beyond the scope. This is not a test of a cadet. This is a bench trial.
I have a rebuttal if you like, Your Honor.
Oh, I love rebuttals. They are my second favorite thing.
He's answering about the probable cause. Reasonable suspicion is tied hand in hand with probable cause. I get that the state doesn't want me to question the skills of a cadet, but if the cadet is charging people with crimes, they should be questioned and they should be accountable for their actions.
Then I will further object for relevance. The cadets' knowledge during their training period shouldn't have. Beg your pardon. The cadets' knowledge of being tested whilst in a bench trial shouldn't have any weight on what actually happened during the case.
I have a rebuttal for relevance as well, Your Honor.
I hate it here.
Would you like to hear it?
Oh, yes, most certainly.
Yeah, to the relevance, if this cadet was searching a criminal and charging him with crimes, the relevance of reasonable suspicion and probable cause is paramount to the case, as that is the foundation for pretty much all policing in the state.
Whatever.
I shall leave it to your ruling, Your Honor, or else we will be back and forthing until the cows come home.
The court will agree. The court will overrule this objection. The witness may answer the question.
I believe the original question was...
what is reasonable suspicion?
How does probable cause differ from reasonable suspicion?
Reasonable suspicion is exactly that. It is a suspicion that the person has was committing, or is committing a crime, which allows a law enforcement officer to detain and frisk the individual.
Okay, perfect. Does reasonable suspicion allow for a search of the person?
It does not.
Okay. What evidence was there for probable cause of the defendant?
He was inside of the store while it was being robbed.
And to be clear, while he was inside the store, he was bound and blindfolded, correct?
Correct.
And also to be clear, did he state anything to you prior to you searching him?
I don't understand the question. Did he say anything? Is that the question?
On the state's examination, you mentioned his statements while you were searching him. Did he state anything prior to you searching him?
Nothing of relevance.
Okay, did he explicitly consent to a search?
He did not.
All right, perfect. Thank you, Your Honor. Nothing further.
Redirect.
Yes, please, Your Honor.
You may be approached.
Hello again, Cody.
Hello.
Firstly, did the defendant resist the search prior to you searching them?
I'm going to object to scope. I asked nothing about resistance or really the actions involving the search.
I am redirecting. I am not cross-examining.
I would further elaborate that redirect is directly based on cross.
I may review the questions.
Of course.
I would. Sorry. I do have a further explanation, Your Honor, should you wish for one.
What is your further explanation?
The defense asked Cody if the defendant explicitly consented to a search. I am merely going alongside that with asking if he, beg your pardon, was resisting one.
Oh.
And to be clear, the objection was scope.
One moment. So resisting having to do with the what is the word? One moment. The court will overrule this objection, but please be very brief. Mr. Graveslaw. Sure.
Thank you, Your Honor. Do you need me to repeat the question?
If you don't mind.
Did the defendant directly resist the search?
He did not.
Okay. Moving forwards a little bit, I know we talked about probable cause. Are you aware of exigent circumstances?
I'm going to object to scope again. I asked nothing about exigent circumstances.
Your Honor, the rebuttal would be as whilst the defense stated that reasonable suspicion and probable cause go hand in hand, the state would affirm that exigent circumstances and probable cause also go hand in hand.
I have further explanation if you need, Your Honor, but I'm at your whim.
What is your further rebuttal?
While those things may go hand in hand, the cross-examination did not touch on exigency or exigent circumstances whatsoever, and so all questions about that would fall outside the scope rather, of the cross-examination, and therefore would not fall under redirect.
Your Honor, if I may.
Oh, please do.
The exigent circumstances going hand in hand with probable cause would fall under the scope of questioning about probable cause, as it has a factor that has an effect on said probable cause. And as such would remain under the scope of questioning by the defense.
I need the dice. Shit, I don't fucking know. I am a terrible yacht. Give me one moment to consider.
Of course, thank you, Your Honor.
Did you dork? Wait, you did dork? Oh no, let me see. They are arguing, exigent circumstances, objecting to beyond the scope. I mean, I think it is important. All you will have to do is recall the witness. Can you recall the witness? Mostly witnesses are wearing exigent circumstances. Did he consent to research? No. This is why I need the transcribing. Let me just pass out here and go to sleep. These go hand in hand. Ah, shit. I don't know the answer here. Mr. Gupta! Thank you for your time and patience. The court is very difficult. I can see the merit of both the arguments. Very difficult though. The court will sustain this objection. I am sorry.
Okay, just a moment.
I can see that it is very important to PC. Why are there so many things objecting? I hate it here.
Okay, no further questions, Your Honor.
Thank you. Would you like recrossing?
No, Your Honor, we're all set.
Anybody planning to be recalling this witness?
No, Your Honor.
Also, no, Your Honor.
Thank you, Mr. Cody Phoenix. You may be released from the court. Free to stay or go as you are being happy.
Thank
This
you, Your
sunny
Honor.
day.
You too.
Oh my god, thank you.
Your Honor, the state would also move to release Sergeant Cherry Weirdsbecker from her subpoena.
Perfect.
No
Miss
objections.
Weir's, thank you. Miss Weir's Bika, you also be released. You can come or stay, whatever make you happy. Are you having any more witness or evidence to be present?
Just a moment, Your Honor. That is a negative, Your Honor.
Perfect. And the state is be resting.
Yes, Your Honor.
Wonderful. Defense, are you having any witness or evidence to be present to the court?
We just want to reaffirm our case law submitted. Let me double check the number on it. I believe it is 24 CM 192.
192.
Just make sure that's submitted. Other than that, the defense rests as well.
Wonderful. Are you being prepared, everybody, for the closing, or you needed the time?
The defense is prepared.
The state would need a couple minutes. Your Honor, I just want to clarify if there was a ruling made on the case law that was presented by the defense, as we did object to it.
The court will allow the case law present to be considered.
Okay, thank you for the information. The state requests a few minutes to prepare a closing statement, Your Honor.
Perfect. You can have 10 minutes. We will resume the court proceeding at the top of the hour. That is all. Oh my god.
Sonny, after you give your ruling, I'm giving a sermon about exigent circumstances and administrative searches because I have such a aneurysm every time I hear what the fuck they're trying to say.
I don't know how to priestess, they are arguing some things that are very powerful.
Yeah, no, I get you. I get you. They're also they're arguing on not only things that are very powerful, but other things they're arguing are just very wrong. they're they're like 50-50 on wrong and things which are federal courts might have some influence upon.
Are
Such a
they?
shit show.
Is this supposed to be how bench trials are supposed to be? Because I thought bench trials are supposed to be brief. This is like a full-on trial.
It's always happening.
Yeah, it depends. I've had one that was like 20 minutes. That was just because they literally had like nothing. They had no witnesses. They had like 3 pieces of evidence that they slapped on the docket, and that was it. It's hard to limit bench trials because like, you never know how long it's gonna take. So I'm assuming you already know how you're gonna rule based upon, things.
Uh, yes, I have some thoughts.
The
Thank you.
defense would like to start off our closing today by exemplifying the testimony of the state's own witnesses that exigent circumstances require probable cause. They say exigent circumstances were the basis for the search, and in the closing, the state prosecutor Graveshaw mentioned administrative searches, which were not alluded to, defined, or described in any way during testimony here today. Quite simply, the state believes that being bound and blindfolded at the scene of a robbery is probable cause that you are involved in the robbery itself. And that is quite simply not enough. That does not meet the burden of probable cause. This search was performed illegally. All items obtained after the fact were and provided to the state today and provided to the courts today are fruit of the poisonous tree. In fact, the state did not actually introduce any evidence during the course of this trial today. All actions performed by the defendant are justified by 2024 CM 192, which finds charges after an illegal detainment or search to be not valid in the eyes of the court. Most importantly, and just to reaffirm once again, the state is using exigency as the basis of their argument, and exigency requires probable cause. Probable cause was not met here today, plain and simple. There is only one ruling that could justifiably be made here today, and that is not guilty on all accounts, Your Honor. Thank you.
Perfect. Thank you so much for those statements. The court will now be on recess for the deliberation. We will be back as soon as being possible, probably within 25 minutes.
All rise. Hey, Sandy, I'm gonna go yell at them. Do you need me?
Oh, you're going to go yell at him?
Yeah, I need to. I'm gonna go teach them what exigent circumstances mean.
I need my glasses. Somebody pointed them off.
Who did that?
Yeah,
Do you need me for anything else, or?
I think I will be okay.
Okay, splendid. Let me pick up your glass.
Oh, thank you.
Here you go. There you are. All right, I should be back.
Shit, I should have did a thing where I go and change after every recess. Damn it.
Well, that's what you should do now, going forward.
Oh my god. Oh shit. Almost being done. This is the important part. What is this ruling? Hmm. This is the part that is difficult. Mm. Almost done. Oh, not that one. I can close that. Remove that. Want to be. Okay, I am being done. We will hopefully, I need to pop this over here. I cannot be reading. Okay. Oh my god, I tried.
Hello, Your Honor.
To go, right?
Mr. Jota, you did not announce me!
Greetings, Your
All
Honor.
rise. The
my God,
court
thank
is
you.
now back in session. Judge de Kavanaugh presiding.
Hello there, thank you everybody. The court is always being appreciative of the patience and attention of everybody being in attendance. All parties is always again presenting the compelling case and indeed the cause for much deliberation. The court also happily taking all attorneys for the much objecting, which did also be the cause for additional deliberations. And making me so happy. The court today heard the case of the state versus the defendant, Mr. Ivar Helsinki, who did be facing the following charges. 1 count of the weapons trafficking, 4 counts unlawful possession of the Class 1 firearm, and 1 count of the fleeing and eluding on foot. The court today considering the following pretrial motions. The defense presenting the case law 2024 CM 192. This did be accepted and considered by the court. The state subpoenaed the witness, Bika and Phoenix, which did also be accepted with no objection from any parties. Finally, the state presenting the evidence exhibits 1 or 7B. The defense did object based on the fruit of the poisonous tree, with the court ruling that it would be considered to the duration of the case. Some undisputed dispute facts of the case today. I need my clipboard. Thank you. There was the robbery at the evangelical store in the grave seat. The officers and witnesses, with Rebecca and Phoenix, did be responding to the robbery, where the defendant, Ivar Helsinki, did be present inside of the store. The defendant, at the time of the incident, did be blindfolded and bounded. When the officers clearing the store, the defendant is no longer being on the scene. The defendant later found in the bush 10 feet away from the location, still being bound. The defendant searches subsequent to this robbery and was found to be in total possession of the 5 firearms, the heavy pistol registered to him, the 4 ceramic pistols not being registered to the defendant. The defendant, Ivor Helsinki, did be running from the officers on the foot. In the matter of this case, the court is finding the following. The court today centered upon the legality of the searching the defendant following his presence as being the hostage during the robbery of the Evangelical Jewelry store. The state arguing the administrative searching and the exigent circumstances, further asserting through evidence and testimony the defendant running from the store and to be later found hiding in the nearby bush. The defendant not objecting to the searching until the recovery of the weapons, where he asserting them to be his, and then later running from the officers. The defense today arguing the lack of probable cause for the searching due to the defendant being blindfolded and bound within the location at the time of the robbery. The defense also asserting the search to be being illegal for the lack of probable cause for the search, and that all items recovered from his person as a result of this search are being the fruit of the poison tree. In regard to the presented case law 2024 CM192, where the court, in this case, that case finding the subsequent search and associated charges to be invalid due to the initial lack of supporting testimony and evidence for the probable cause or reasoning for the stop, this court today finding that case law to be significantly differing from this case upon several major points and therefore cannot be being applied. This court today will assert that the subsequent searching of the defendant following the robbery at the evangelical store was being the legal searching of his person. While the exigent circumstances do not necessarily being applied to the individual person, the probable cause for the searching did be established by the presence of the defendant for being on scene inside of the building at the time of the robbery. Furthermore, the subsequent actions of the defendant, who did be running from the scene while bound, and to be hiding inside of the bush after being the hostage, did further be establishing the probable cause for the searching. As such, for the one count of fleeing and eluding by foot, the court will find the defendant, Mr. Ivar Helinski, to be guilty. The officer, testimony, and evidence presented to the court asserting the defendant, Mr. Helsinki, after being searched, did be running from the officers on foot. In running across mountains and after being free from the zip ties to be put into the handcuffs, did be continued to resist and break free from the cuffs and continue to be running. For the 4 counts of the unlawful possession of the Class 1 firearm, the court will find the defendant, Ivar Helsinki, to be being guilty. The officer testimony and evidence presented to the court asserting the defendant, Mr. Helsinki, after being searched, did be, evidence and testimony presented to the court showing the defendant to be in possession of the 5 firearms. The 1 heavy pistol that did be legal and registered to his person, and the 4 ceramic pistols not being registered to Mr. Helsinki. As the ceramic pistols did not be registered to him, they were being unlawfully in his possession. And for the 1 count of the weapon trafficking, the court will find the defendant, Mr. Ivar Helsinki, to be being guilty. Evidence and testimony again clearly demonstrate the defendant's possession of the 5 firearms at the time of the searching. The 1 heavy pistol again registered to him, and the 4 ceramic pistols not registered. As such, the defendant is in possession of the 5 or more firearms at the time of the incident and was found to be doing the transportation of those firearms. Are there being any sentencing recommendations from the state?
Just a moment, Your Honor. I believe I have recommendations actually written down. Cherry, can you get out of the... Just a moment, Your Honor. The MDT is having a technical problem, so we're just calculating recommendation numbers.
Oh, milk and honey tea. Yummy. Oh, let's check this.
Your Honor, the state would move to recommend a sentence of 110 months and a fine of $3,250.
Defense, are you having any what is the word, counter recommendations?
Given the amount of time we've been here today, I would request some time served for my client. I mean, that's really all we have from the defense.
How long have we been here? 2 hours.
Your Honor, if I may.
Yes, you may.
Of course, I trust in your ruling. However, a defendant's right to a bench trial and right to legal counsel shouldn't have any weight on their on any time being served, and as such, the state would move with its prior recommendation.
I think I'll do
I
50%.
mean, he did also spend time as like the hostage as well.
I see that as irrelevant, Your Honor.
110 is 55. The court will be sentenced the defendant, Mr. Ivor Helsinki, to the 55 months and the $3,250. That is all.
Thank you, Your Honor.
Your Honor, if I could talk to you.
Hey, you meant me or the?
I mean, Sonny. Sorry.
Yeah, go ahead. Yeah, I'm walking this way anyway.
Hey, Sonny.
Yes.
So you think there was probable
Okay.
cause
Oh, sorry, go
for
ahead.
them to search him?
Go ahead.
I'm sorry, Sunny, but I was very annoying halfway through
Yes,
it.
me too. Many
I now-
objections.
I now
Sometimes
have
they
to
flip the coin.
review the transcription, Sunny. I
To
now
make
have
sure
to
of what you're saying. Listen, cannot use mine. Do not use mine.
we can use mine, but pity me because I have to go through the whole 2 hours over again, Sunny. Because
Oh,
I need to
if
remove all pauses.
oh my god. Why did I take this case? It's too much. It hurt my brain. Oh my god.
Except that we are different as excuse for bad rulings, and I think this was an incorrect ruling. That's quite simply what it is.
Hi, Sunny.
Heather.
Hello.
You've got an infinite amount of time to appeal, but I'd say learn when to leave it alone.
I'm sorry. I'm just not going to be convinced that victims of bank robberies or jewelry store robberies should be able to be searched at a whim. I will not be convinced of this. If something was
This
put
will
on
have
them,
to be
sure,
a support
but like both witnesses said no, they didn't put anything on them. And I get that we're different, sure, whatever, but that doesn't mean that we should be so different that people's rights are infringed.
We are lucky that we have the protections that we currently have. A lot of states, like ours, do not.
I think we have vastly reduced our protections in the last 30 minutes. That is.
I believe it was more like 2 hours.
If I call 911, I can be searched now. That's just as simple
No.
of it.
That is not true.
Hang on, no, that's not true.
Yeah, yes. If I call 911 and
Case
say
law to the contrary.
somebody shot here today,
That's good.
Okay, we're going to end the streaming. I am going to sleep. I'm very tired. Thank you for hanging out. I don't know. He's going to be going on for a very long time. It will probably end up in support ticket. The issue is, in this city, it is impossible to observe, really, the transferring of items between people. If that makes sense. Like, I cannot physically see what you are giving to them. If I am conducting a frisk following a robbery, I cannot feel whether or not they have 500 pounds of gold watches on their person. It is not a possibility due to the mechanics of the server. That is why this search is necessary. I would love to be able to trust that people are honest, but there are so many people that also volunteer to be the hostage. Yes, I am looking to be the hostage. I am so bored. So there are issues that for the server mechanics it must be done. Let's see. Open. Oh. Or is it that? Oh. This one pretty good.
Attention all, I'm Judge Sunny Day, here to rule in a respectful way. No whispers, please. No phones to see. Wear your mask.
Let me find somebody.
If you feel ugly,
That's my favorite line.
courts in session, rules in place.
Where's the red window?
No side chatter. Respect this room. It does matter. Boards in session. Rules in place. No distractions. Serious face. No loud hats. No side chatter. Respect this room. It does matter. Order now. Court's begun. Simple rules for everyone. Wear a smile or mask your grin. We seek justice. Let's begin. Boards in session. Rules in place. No distractions. Serious face. No loud hats. No side chatter. Respect this room. It does matter.
The emoji they running out of this on the day and the above average net. We'll be back tomorrow, hopefully. Bye.